The last body of law that's relevant here is international human rights law. International human rights law is a body of law that protects the nationals of a state from the arbitrary or overreaching power of the state from the deprivation of rights. It is entirely a vertical body of law. It only places obligations on the state, public officials, in terms of to protect the rights of citizens against the overreach of the state. To the extent that these drone strikes take place outside of an armed conflict, so you don't have this law of armed conflict paradigm, human rights is going to have something to say about what kind of actions a state can take under what circumstances and so on. I'm sure we'll get to all these things in questions, so I'll leave that as a background statement.
Okay, thank you, Laurie. Azadeh, I want to start with you. And you referred to the killing program, right, and you referred to it as vast, unlawful, and secret. And then Todd told us that the killing of Anwar al-Awlaki was perfectly legitimate. And so I'm wondering how you respond to that specifically.
Well, definitely it wasn't, and that's, that's the lawsuit that we have brought.
Right.
He was a U.S. citizen for one thing, so the Constitution of the United States applies to him. And again, the basis of our lawsuit is the privation of life without due process of law. And Mr. Awlaki was not given any type of due process of law, which is, normally what the definition of that is, going before a court of law, obtaining a warrant for an arrest, or definitely before subjecting somebody to the capital punishment. We see in this country there's multiple levels of judicial process before the government can put somebody to death. And in this case, what we had was the president basically acting as the prosecutor and the judge and the executioner, and the next thing you know is that this man is dead. So, the administration might have some evidence about the danger that this man poses to the American public, but that doesn't erase the responsibilities and the basic guarantees of our Constitution, not to mention international.
So what is the basic guarantee of due process now, right? I mean, we all learn in civil procedure it's notice and an opportunity to be heard, right? And that's obviously given here, but maybe that's not applicable in the setting of a war, right? So I guess among the questions are, is that the right way to look at this? If not, what is the right, what is the basic due process protection to which Mr. Awlaki was entitled and didn't receive?
That is in fact the right framework to look at it, because again, we're dealing with U.S. citizens in a country, Yemen, with whom we're not in war. So, the framework that applies is the Constitution of the United States. If Mr. Awlaki was captured, he could be brought to the United States and put through a trial, like, a lot of other defendants have been in the post-9/11 context, and in fact have been, many have been found guilty and are serving time right now. So that, we shouldn't, confuse the different frameworks, and we have to, have a clear understanding of what framework applies. And it's our position that, at least when it comes to U.S. citizens, it is the Constitution that is the framework. And, especially again, when you're talking about a context that's not a war zone.
Right, but, okay, so the Constitution is the framework. I don't think anyone would doubt that. The question is, what is the Constitution guarantee? So, if the president determines we can't capture al-Awlaki, what's he supposed to do?
Well, I guess there is questions as to whether or not individuals that our government has killed could or could not have been captured. For example, the Yemeni man who testified before Congress, some of y'all may have heard him, what he told the American public and Congress was that the individual that was supposedly the target of a drone attack and was killed, he could have very easily been captured, because everybody in the village knew him, and he could have been turned over and captured. And so, that is, again, when the individual is captured, they're brought before a court of law and are afforded the process and the procedure that normally defendants in the criminal procedure system here in the U.S. are afforded.
So then just the president can't make the determination somebody?
Well, if it's not practicable to capture somebody at this moment, then I guess you have to wait until it's practicable to capture them. You can't just kill them. That's just not, without any type of, due process of law, judicial procedure, the president cannot kill a U.S. citizen on his own accord. Again, unless there is a exception to that where, lethal force can in fact be used as a last resort where there is imminent threat to life. So in fact, if there's evidence out there that this individual, was gonna either incite an attack or kill somebody tomorrow, he could not be captured. There's just no way, and this was the only way that we could prevent that imminent danger to life. Then that would be an option. But at the time that this killing occurred, first of all, it was completely secret. Second of all, the administration refused to provide, even acknowledge it, or provide any evidence how this person posed danger to us. And definitely there was no explanation.
Todd, how do you respond to that question? What does the Constitution?
Just my mind felt like the storm outside. Trying to kind of figure out exactly kind of where to focus here. Let's just take Honorable Laki in context for a second. Here's an individual who has unilaterally joined our enemy. We have, in our Constitution, we mentioned treason. We have a statute against treason. But here's a guy who is actively fighting against the United States of America in a war that we have authorized and declared by the U.S. Congress and being executed by the President of the United States. So just in a broad balancing act for a second, just to think about the things that we know we can do to people who are fighting against us. Had Laki been on a battlefield, even in Yemen or say in Afghanistan, and pulled a gun on a U.S. soldier, no doubt that U.S. soldier could have killed him. And that's effectively what he was doing from Yemen, is he was launching an attack against the United States and trying to kill Americans. And I'm up here with two law professors, so I'm not going to go through the substantive due process balancing test that courts do. But yeah, he does have some substantive due process rights. But it's up to also our government to balance those rights versus our interests. And our interests certainly are to protect the safety and the security of the American people first, and his substantive due process rights second. And I think the American people expect our Constitution to work in a way where we don't allow a guy who has joined the enemy, who is plotting against us on a daily basis, to have his rights protected when Americans are killed while we sit there and wait and do something about it.
Laurie, you are a law professor. What do you think the Constitution guarantees to someone in that kind of situation?
Well, I think the citizenship question actually is a red herring here. I think the Constitution, I agree that it guarantees due process of law. I think in the context of a war, distracting from the jingle. Let's envision it's 1942, and we're fighting against the German army, and I can guarantee you that somewhere among the millions of men that the Germans put on the front lines, there was a U.S. citizen. In fact, one of the saboteurs who came here in 1942, who was then captured, actually, they turned themselves into the FBI, was, at least one was a U.S. citizen, if not two. There was no situation in World War II in the context of such a battle, where, we had tanks and whatever, where we asked to see ID. I know this sounds very glib, but the question of whether or not someone was citizen was entirely irrelevant because they were fighting with the enemy. During war, if we're operating in a war framework, the method by which we determine who we can target, who we can use lethal force against, is twofold. We can use lethal force against a member of the enemy forces. So if we're fighting against the state, then it's going to be someone in their army. They're most likely wearing a uniform. It's ideally pretty easy to identify them. The law says we must distinguish between these people and people we're not allowed to kill. So a member of the enemy forces, or someone who, what we would call a civilian, which means someone not part of the army, not part of the enemy forces, who is at that moment directly participating in hostilities. So a German taxi driver was not in the German army, but grabbed his rifle And as U.S. troops came into his village and started shooting at them, at that moment, he was somebody that U.S. forces could target because he was directly engaged in the hostilities against them. He was driving his taxi down the street, no, would be protected from attack. So if we take that same construct and we put it into today's situation, which is admittedly much more complicated, simply not because the law is more complicated, it's the same law. What it is a situation in which we're not fighting against an enemy who wears a uniform, who has ranks in an army and units and battalions and brigades and so on, and who is fighting on the territory of one country. Instead, we have members of an entity, a terrorist organization, and the question is trying to understand who is fighting against us in order to figure out who we can then fight against, because we're trying to destroy, degrade the capacity of this enemy to fight against us. Your purpose in war is to defeat the enemy as quickly and efficiently as possible within the boundaries of international law. You cannot step outside the boundaries of law and say, well, it'd be great if we just slaughtered everybody in sight, women and children and so on, because that would make it a lot faster. That's not one of the considerations. So with al-Awlaki, I would generally agree with Todd in that to the extent that we identified him as a member of al-Qaeda, the entity against which we are fighting, then he is a legitimate target of lethal force at any time. At any time. Now that may sound barbaric or harsh, or it certainly sounds unpleasant, there's no doubt. But war is a different situation than peace. And it requires, again, what you're trying to do is not stop the threat of an individual. You're trying to defeat a collective corporate entity, and that's the armed forces of the enemy, whether it's a state or an organization. In order to do that, you may kill somebody who's a member of that organization who isn't even posing a threat at that exact moment, because by doing so, you are fighting, you are enhancing your ability to defeat that enemy as a whole. So, for example, let's go back to the World War II example, German soldiers sleeping in their barracks could lawfully be targeted. By doing so, you are degrading their ability to fight against you. Every time you do that, you're helping your own ability to beat them. So the fact that he's a U.S. citizen, while he's in Yemen plotting attacks for our enemy, to me that is not relevant. If you look at it through the constitutional lens, and you want to look at it as, well, he's entitled to due process of law, I agree. But the question is, what law? It's not notice and opportunity to be heard in my mind. It's the due process of the identification of a legitimate target of attack within the law of war.
Wow.
I believe that was done. Again, I wasn't sitting in the room, but based on the information we have, that seems to be what was done. We don't offer any of our other enemies a court date before we target them on the battlefield, so the simple fact that this is a different kind of war doesn't introduce that calculus to me. If he were here in the U.S., I might look at it a little bit differently. I would probably require much greater imminence in the threat that he was posing, just because of the difference in where he is. Why?
Right, the battlefield is everywhere.
If the well, I don't. Right.
This is everywhere.
So this is interesting. I don't think the battlefield is everywhere. Traditionally, under the law of war, the U.S. should be the battlefield, because we are a belligerent in this armed conflict. We are one of the parties that's fighting. So we should be part of, just like we were during World War II. Our territory was part of the territory of the armed conflict. And yet, but here, the U.S. has very, very specifically excluded U.S. territory from what it seems as let's make up, a word, combat zone, which is not a legal term in any way. Neither is battlefield. It's not a legal term. Every court case on detainees that has talked about where they are, talked about the U.S. as outside the battlefield, far from the zone of active hostilities, outside the combat. They use every possible way, which is very interesting to me, because the law would suggest otherwise, that the U.S. is, in fact, belligerent territory. But But if the U.S. views it this way, I think that it doesn't get to view it that way only for its own purposes. It would have to extend that same view to the protection of the people on it. So I wanted to throw out one more point. I think it's important also to recognize the difference between a policy being lawful and a policy being wise. The simple fact that I may think that over many drone strikes fit within a parameter of international law doesn't necessarily mean that it's necessarily a wise. I mean, I think you can look at something as lawful but not wise or effective. There definitely are differences between the two.
Okay, right. When I worked at the Justice Department, we referred to that as awful but lawful.
That's what it is.
But I'm curious, though, Todd, do you agree that if Anwar al-Awlaki was walking down the street in Chicago, the president could order a drone strike against him?
I think Laurie hit it.
We've said we won't, right?
Right, I think Laurie hit it. I mean, there is an imminence component to this.
Does it matter whether it's here or in Yemen, the imminence component?
It does, because if it's here, our capabilities are a lot greater. I mean, if he is walking down the street in New York, you have local PD, you have the FBI, who could perhaps take action to stop him from doing something. If he had a suicide vest walking down the streets of New York, you could use anything you needed to stop him. And I would even argue that you could use military force. If that is the only force that we have in our arsenal capable of stopping him, then we could potentially do that. But I think one of the hardest challenges about this war that we're fighting is the fact that we're dealing with different stratifications of an enemy. So we're dealing with Al-Qaeda core, the people who attacked us on 9/11, who sat there in caves and planned the planes operation, who planned the bombings of our embassies in Kenya and Tanzania in 1998, USS Cole in October of 2000, the attack of 9/11. That core Al-Qaeda is one part of it. But we've seen our enemy change over the last 12 years. It is no longer just core Al-Qaeda. It's a series of organizations all over the world, primarily in North Africa and the Middle East, that have sort of adopted the same ideology and the same tactics to achieve that ideology. The ideology being Islamist ideology, the tactics being violence. We have Al-Qaeda in the Islamic Maghreb up in Algeria, Boko Haram in Nigeria, Al-Qaeda in the Arabian Peninsula in Yemen, Al-Shabaab in Somalia, just to name a few. But these groups are primarily regional. Their targets aren't necessarily here in the United States. But point being, that is a whole another stratosphere of enemies out there who are against the United States and who, in some cases, actively plot against the United States. AQAP in Yemen is perhaps the most aggressive of those franchise groups. And then we have a third category of individuals who are inspired by ideology who plan attacks here inside the United States. Since 9/11, we've had 65-plus attacks, plots here in the United States. We've had 3 successful ones. That's an important success rate that we've had here in the U.S. So I think in terms of we have to sort of define the enemy as a sort of different concentric circles. We're engaged in using different tactics to defeat those enemies.
Is that last group the enemy in the legal sense?
I would argue, yeah. I would argue if you look at authorization of use of military force,
it doesn't say anything about those inspired by the attacks of 9/11. It says those who perpetrated them and those who harbor those who perpetrated them.
For the purpose of preventing future attacks. I would argue...
Or anyone else for the purpose of preventing future attacks?
Kind of right in front of me.
Okay, it doesn't say that. It's 28 words long. Those aren't among the 28 words.
I would argue over time, if we are going to reevaluate the most of the president talked about it, then I think that's part of the debate we have to have.
Okay. Azadeh, you've been very patient. I take it you take issue with some of the things that have been said.
Right. I mean, I think one thing we need to look at is where are the strikes being launched. There's a difference between Afghanistan and Yemen and Somalia and Pakistan. We're not at war with Pakistan or Yemen or Somalia, whereas we are at this moment in war with Afghanistan. So in terms of, launching attacks, again, you have to look at whether this is a country with which we are at war or not. And if we are not at war with this country, then we cannot just attack people and drop drones on them.
Well, I think one of the points of disagreement here may have to do with imminence, right? I mean, I think Azadeh, you accept some use of force where there's imminence, but you define that as something we know is going to happen imminently, as that term is normally used, right? Like immediately or very, very soon, and something drastic, right? Whereas Todd, I think maybe you have a more capacious understanding of the term imminence, one that maybe is more consistent with the Justice Department's white paper.
I think the white paper that was released out of, I guess, MBD's release of the DOJ white paper about the rationale behind the drone strikes in Yemen, especially against al-Awlaki. I do agree. I mean, the word imminent sort of loses its meaning in that white paper in the sense that it's not going to happen tomorrow, or right now, but we just don't know when, but we know it's almost certain. And so that very elastic definition of imminent, I think, is justifiable.
All right, justifiable how?
For the purpose of carrying out and executing the war that we're engaged in.
No, I understand why it might be a good thing, but I'm wondering, where do you get this more elastic view of...
Because what we don't know.
So practicality.
Yes.
I'm looking for a legal basis.
Well, I'm going to give you a practicality answer.
Okay.
Because at the end of the day, the people who wake up to defend us every day, who are responsible for doing that, are thinking in practical terms and then looking for legal justification to what they need to do.
Laurie, do you have any sense about the Justice Department's view of imminence, whether that's well-founded or whether, in fact, they're playing a little fast and loose with the law there? It's interesting to me that the white paper is that, a white paper. No one's taken responsibility for it.
I think the way they present the word imminent, it loses all meaning in the white paper. I think another problem with the white paper, with the president's speech, with all the speeches leading up to it, is that the U.S. justifies every use of force with two legal justifications. One being we're at war with, we're in an armed conflict with some group to which this person belongs, and I say and or because we don't know whether it's and or, we're acting in self-defense. So these are two of the legal frameworks I mentioned at the beginning. They don't have the same parameters for when you can use force, and they're not used for the same purpose. So one problem is that imminence is becoming very confused. If we're operating in a wartime situation so that the law of war applies, imminence is simply not, it's just not a word that comes up in the law of war. Somebody doesn't have to be posing an imminent threat in order to be a target during wartime. A member of the enemy forces is targeted all the time. The only time imminence, and it's not used in this way, but when you talk about that civilian who picks up a gun and is participating in hostilities, that's a little bit akin to imminence, because they have to be participating at that time. It's only for so long as they participate. When they stop, they go back to being protected from attack. But again, the word imminence, it just doesn't appear. It's not a term in this body of law. Where imminence is relevant is outside that body of law. So you're targeting somebody solely on the basis of self-defense against the attack they are either launching, about to launch, in order to defend against that. Then imminence is one of the key factors in determining whether or not force can be used at that time. The U.S. has kind of mucked these together, and they'll talk about the imminence as a consideration when targeting someone in the middle of an armed conflict, which is not right. So that then when they talk about it in the context of self-defense, you don't know what they mean, and they have stretched it essentially so far to me that I don't really know what it means. I think one description I've seen, not just in another colleague of mine who works on these issues, is the idea in the terrorism context of the last window of opportunity. So if you think about the classic idea of an imminent attack, I'll give you the best example I can come up with that's not a terrorism example, is the Six-Day War, when Israel had the forces of Iraq, Syria, Egypt, Jordan, so on, massed at its borders. So you think back to the good old days when, you actually drove tanks up to the border and you massed your infantry, and they were actually standing there on the border. So the attack was imminent, and Israel launched the first strike. That was called anticipatory self-defense. They didn't wait to be attacked. That to me is the definition of imminence, the way we might have understood it before we think about terrorism. Well, if you think about a terrorist plot, there may be a time, days, weeks, or months before the actual attack is launched, when it's the last window that you have to stop it. Because something gets put in motion, right? We've all seen the movies, read the books, and you know, whether it's fiction or not, a plan gets put in motion, and maybe they no longer have contact, you can't be stopped, et cetera, et cetera. So maybe it's not the day before. Maybe it's not the moment before. Maybe it is 5 weeks before, when al-Awlaki is about to give the final instructions or finish the last puzzle piece in the plot. That's the moment when imminence actually is happening. So I still think it has to be narrowly understood. It can't be, gee, that's a bad guy and he doesn't like us. That's not imminent to me. So, but I think this conflation of the two things has created an enormous amount of confusion and inability to understand when the U.S. is acting under what parameters and therefore if it's lawful or not.
Well, is it a conflation? I would have thought that the imminence component is a requirement of due process. That is, if someone is imminently, using the term literally, about to strike the United States, then the process that is due to them is less than it would be if that strike is going to come in a week, and less still if it's coming in a month, right? And isn't that where it comes in? And isn't that where perhaps the distinction between a U.S. citizen and a foreign national is relevant? Because if the strike is to occur abroad, to whom do due process rights attach, right? U.S. citizens, they do. Foreign national abroad, I would tend to think the answer is no, they don't, in which case the imminence requirement might apply to a U.S. citizen, but not to a foreign national.
That's where I would disagree, because constitutionality is not the only framework that governs it. A foreign national is no less protected from the arbitrary use of force than a U.S. citizen. A foreign national still has the right to life. We're talking about international human rights law here. They still have the same rights, sort of like if you think of John Locke as sort of natural rights. They have the right to life. That can't be arbitrarily taken away from them. To me, imminence is a component not of due process, but of essentially the use of force under what we call law enforcement or human rights law. And so,
well, I
guess to me the citizenship, again, to me it's a red herring in general.
Is that the due process clause guarantees a kind of protection that the law of war can't override, right? So the law of war may have its own minimal protections that wouldn't meet the standards of due process under the Constitution. U.S. citizens get those no matter where they are, as against the United States government. And foreign nationals, if they're abroad, don't get those constitutional protections. They get whatever protections may exist out there in international humanitarian law. And if the latter is a lesser protection, well then that's the one we would follow if the target of the strike is not a U.S. citizen, and the greater requirement of due process would be the one we'd follow if the target is a U.S. citizen.
Actually, I want to throw a wrench in the whole discussion here, I'm going to borrow from one of my colleagues, and in fact, I don't think it's really due process. It's the Fourth Amendment. If you think about it, search and seizure, it's a seizure when you kill somebody, in essence, or capture them, obviously when you capture them. And so it's not clear that we're only talking about, if you're talking about the Constitution, the Fourth Amendment has a role to play as well when you're talking about a U.S. citizen. But imminence, to me, again, doesn't come about when you're in an armed conflict. A U.S. citizen who's a member of an enemy force has no more protection than the other members of that enemy force. Again, we didn't provide any greater protection to U.S. citizens who were fighting for the Japanese or the Germans or the Bulgarians or the Italians for half the war or whoever else. they were part of a German unit. They were just as likely to be killed as any other German or other citizen as part of that unit. So, during wartime, I don't see the citizenship issue as playing a role. Now, if upon capture, and you capture them, and you find out that somebody is a U.S. citizen, that might change conceivably your decision about where and how you hold them and whatever.
Okay, but then that creates an incentive not to capture them, right? Kind of a problem.
So, you know, I just, I have to say, and this may be my bias since I work very closely with a lot of folks in our military, I know that it's a commonly thrown out claim that we're killing instead of capturing because it's easier and we don't want to capture people. I think before we make that statement or agree with it, I think it's really important to stop and think about what it means to kill somebody. Whether you do it directly with a gun, whether you push a button so that a drone launches, it's not a casual thing. And the folks in our military and other militaries and wherever else, I can't speak for the members of Al-Qaeda, who I don't think have great compunction about it, but I don't know. It's not something that is done lightly, and it carries great moral repercussions for the rest of their lives. So I'm really hard pressed to imagine a scenario in which we kill because it's easy in a practical manner, rather than because we believe it is an essential component of our ability to defeat the enemy. So I might be wrong, but I just want to throw that out there as a consideration as we think about this. That, you know, we talk here in almost like an ivory tower, and we're up high watching the storm, but it's not an easy thing at all. Just because it's something that we can talk about and it happens on the battlefield all the time. It's not something that is done with sort of an easy or light feeling.
Well, I've monopolized question time, so I want to open it up to the audience.
Yeah, I can't read your last name, Laurie's first name.
Professor Blank.
I really think you have confused the issue far beyond where it needs to be. You first cited 3 areas of international law as being the bodies of law. You didn't even mention the Constitution. The Constitution applies to American citizens. It's the supreme law. No international law trumps it. It gives Americans the right to procedural and substantive due process. None of the other international laws can take it away. Now, under due process, we've got a long body of law of allowing any person, not just military, in defense of themselves or others, to use reasonable force, including deadly force, to defend themselves or others from imminent death or serious bodily harm. That's an established body of law in this country. It's been that way for a long time. You don't need any other authority when someone is shooting at you. The police use that to shoot back. They don't need any other law. When someone's shooting at a police officer, military person, whatever, you can defend yourself, if reasonable and needed, or you can defend others using deadly force. You confuse the issue because when you're in a wartime situation, you don't want to distinguish between American citizens and the enemy. First you say, well, we don't know who's out there. That's true. And if an American citizen gets killed because they're out there and we don't really target them personally, too bad. That's not illegal. But if you know the person's an American citizen, and you are not protecting yourself or others from imminent death or serious bodily harm, that American citizen has a right to procedural and substantive due process that you cannot take away. And if it's inconvenient or even impossible to capture them with police or military or anyone else, that's tough. I'm sorry it's a problem. I'm sorry it's inconvenient. That's what the Constitution says. They're an American citizen. If it's a Jack Bauer moment and they're about to push the button, sure, you can shoot them. But if not, you got to arrest them or leave them alone. That's the way it is.
Okay, thank you. Laurie, do you want to respond to that? Or?
Sure. I would start by saying that international law, the law of war, as enshrined in a number of treaties, including the Geneva Conventions of 1949 that every country in the world has ratified, are the supreme law of the land, just as much as the Constitution. And we are bound by that law, even if it is made outside this.
You're very wrong.
I'm sorry, I'm not.
No treaty.
The supremacy clause covers that. He's absolutely right. The supremacy clause trumps
Take away
that.
our rights
That's
from
right.
the Constitution. Can't do it.
I'm not talking about taking away rights. What I'm
Sure
talking,
you are.
excuse me, I'm not talking about taking away rights. What I would ask you to think about is there is a very big difference between the law that applies during peacetime and the law that applies during wartime. And the law that applies during wartime says that you can target the enemy. You have to determine that the person you are targeting is in fact the enemy. You don't use force indiscriminately, but you can target them with lethal force, regardless of whether or not they pose an imminent threat to you at that time. You can target them at any time. Now, the simple fact that we have different capacities and capabilities in terms of being able to read somebody's driver's license from 30,000 feet, which we didn't have 10 years ago, doesn't change that fact. If the person is a member of the enemy forces, we can target them at any time. During the American Civil War, every person that we killed was an American citizen. We killed them in battle. We did not offer them a court date before we killed them. It's not a question of convenience. It's not a question of that it's pleasurable to kill them. It's simply the legal framework that applies and the nature of military operations and the nature of wartime. Outside of wartime, absolutely, you can only use lethal force in defense of yourself or defense of others, and it has to pose an imminent threat. That's the law enforcement paradigm. It comes from the Constitution. It comes from international human rights law, whichever one you prefer to look at. But this is not a situation where we're talking about taking away somebody's rights. This man, whether it's Anwar al-Awlaki or somebody else in his situation, he is a criminal. He's a traitor to the United States. He happens to also be a member of an enemy force with which we are at war. Changes the calculus altogether.
So one thing that kept getting on, keep saying, or you were saying that we're at war. Well, first off, there's been no formal declaration of war since World War II, as I'm sure we all know. Also, so the authority for this comes from the AUMS, arguably some other types of legislation. So that's different. So this is an executive order. This is not military action. Now, it might be changing to that. We had that speech where President Obama recently was saying he's going to hand some stuff over to the DOD, but it's not official military action. It's just executive order. Similar to what you were talking about earlier with Libya, Kosovo. These were arguably governed by the War Powers Clause. This is something I thought we kind of should talk about, how that should, in a sense, govern these actions. The War Power Clause, where they have to get congressional authority to carry these things out, which is not being done. Now, one thing that, since it's, I guess I've had a lot of little rambling here, I just wanted to point out that it wasn't, there is no formal declaration of war. Also, since we're talking about Anwar al-Awlaki, I don't know who all has read Jeremy Scahill's Dirty Wars, that's the main character in the book for the most part. It's worth mentioning that now Arlaki isn't this like a demon type character. He's some terrible stuff. But initially after 9/11, he was invited to the White House for dinners. He was on talk shows. He was, and he had never become political before that. He was a cleric. But he was out there denouncing these actions by Al-Qaeda. He was saying this is not the Muslim way. Now what happened, as the war escalated in Iraq and Afghanistan, Anwar al-Awlaki became radicalized. He started to fear that it was becoming a war against Muslims, not a war against terrorists. He actually, ended up going to Yemen, as we all know, and while he was in Yemen, he actually was captured by the Yemeni government and held for over a year. Then they were let out, because there wasn't enough to keep them there. So the whole idea that al-Awlaki was uncapturable seems to kind of be refuted by the fact that he was captured before. I think that was brought up before the war. We couldn't capture him. He was going to plot terrorists. And then one thing that you brought up, since he is a U.S. citizen and due process and protect the Constitution, if there was evidence saying he was planning an attack, such as the Barr or whoever else it may be, and it was imminent, why no formal indictment? Obama could have went to the courts, sought an indictment, and then asked the Yemeni government to turn him over. And then perhaps, if capture was impossible, they would at least have a justification saying, look, these are the crimes. But to this day, no evidence has been overturned. And one thing I guess from my question here that I'm going to say at the end, signature strikes, which comes from the same type of thing, end up killing. When Holder released recently that 4 Americans had been killed, finally confirmed it, even though he'd been denying it for a long time, he said only one of them was specifically targeted. He said the other 3 were part of these weren't specifically targeted ones used. So basically confirmed the existence of signature strikes. Now signature strikes are this idea basically, say you're in Yemen and you're in a compound, you have to be military age male, and you're moving fertilizer in and out of the compound, and you do that every day for a week, and they happen to watch you do it. Well, you might be building bombs, so you now are a military age male that is subject to a potential drone strike under this signature strike idea. Something that's developed under the Bush administration and it's been solidified under the Obama administration. So I just would say, your thoughts on the signature strikes, where the Constitution authority comes from that, and also, like I said, if Emory was actually guilty, why was there no formal indictment? And then now why is the administration withholding the evidence against them? So I said a lot there, but mostly I'm interested in what your thoughts on the legal authority for these signature strikes come from, which, other than through JSOC and other clandestine operations, there really is no legal basis for it.
Yes, thanks for very thoughtful. I hope our response is equally measured up. I'm going to offer kind of a simple response. I think the authorization to shoot and kill al-Awlaki with a drone comes from the President's Commander-in-Chief powers and the fact that Congress has spoken on the issue. Congress has the declaration of war responsibility. Instead of doing that, they authorized the use of military, which is a very important word in the ECM there. And you were saying they didn't authorize the military, but that is exactly what the AUMF is. And there's also, we're getting back to the language of the AUMF, but there's the second half of it is, this is consistent with the war powers resolution, so the AUMF takes, takes that into account when it was drafted and passed. And to me, that, it's not going to make you happy, is enough for the Commander-in-Chief to take action to kill somebody who was actively plotting to kill our family, which is what he was doing. Now, you can almost look at every one of those 65 plots I mentioned, 2/3 perhaps. Anwar al-Awlaki was an inspirational figure in those people doing those things, including very specifically Nadal Hassan at Fort Hood, who killed 13.
Well, those emails are, excuse me, I don't want to interrupt you, but when Hassan contacted al-Awlaki, I just read Dirty Wars like last week, he was generally disinterested in what Hassan had to say. Hassan was talking about setting up a dating website and finding a Yemeni wife or something. He's like, I'll look into it for you, bro. That's how they extended those emails, which have been declassified and never went to read it.
Well, I think we can look at in that case, al-Awlaki was acting as sort of a spiritual, inspirational figure, not an operational figure. He did not tell Hassan to go do that. He did not direct him to go do that. But he was spewing the ideology that inspired people to commit attacks. Now that's a really delicate area because of speech and religion, and that's the place where we haven't gone. Where we have gone is when people have become operational, which is what al-Awlaki was doing, which is actually sitting overseas, meeting with folks, figuring out a way to kill Americans, and that, to me, that is the #1 job of the President of the United States. And if they have the intelligence I trust them to do that, and if we don't like that, we then go to our representatives, and we say, you know what, this AUMF is too broad. And if we go back to Justice Jackson's three-part test on when the courts defer to the executive branch on operations overseas, when Congress has spoken and the White House, acts within the context of that speech, the courts defer. If we want that to change as a people, as a country, we need to go back to our elected officials and say, you need to rescind the AUMF. And President Obama talked about doing that at the NDU speech, and we need to rethink how we're fighting this. But right now, the legal framework is very much in place to do exactly what the U.S. government did.
Even for these associated forces and these signature strikes, which, we're not exactly sure the criteria they use to make those because it's not been released. But, recently there was that meeting on Congress over these exact things, and you had the DOD essentially saying that this could be another war that goes on for 20 years, not only because they're no longer specifically targeting high al-Qaeda officials, they're now targeting associated forces. And I think it was independent senator from Maine, King, that said, you basically took what we gave you and completely redone it, and this is a never-ending war unless something's done.
And there's no bigger sin in Washington than overreach. And sometimes when somebody like Congressman Senator King, a very even-keeled guy, former governor of Maine, says that stuff out loud, we begin to see the thought process change in Washington. And there is an emergence of a sense of like the AUMF is too broad. And the White House, both a Republican White House and a Democratic White House, have taken it to an extreme, and we need to pull them back. And that's the way our structure, our system is set up. And I think some of your passion is what's catching fire in Washington. I think it's going to have its day in court there. It's probably just going to take a lot longer than you'd like.
Thank you.
A couple of things. First of all, you don't need to have a declaration of war in order to have a war. War is actually just a political word now. It doesn't have any legal meaning whatsoever in international law.
Well, the founders had no meaning whatsoever for the word, I'm sure. Give me a break. It's in the Constitution.
Okay, you can respect.
In the law that governs wartime conduct, the word war does not have a legal consequence now. The term used is armed conflict, specifically to prevent countries from saying that they're not at war because they did not declare war. So, for example, the Japanese, when they went into Manchuria in the 1930s, you may be familiar with the rape of Nanking, some of the most horrific atrocities that have been committed ever. The Japanese said, we don't need to abide by the law of war because this is not a war, this is a police operation. I don't know how many thousands of troops they had. It was clearly a war. They just chose not to call it one. The U.S. has also done that in the past. We said when we went to Panama, it wasn't a war. We tried to finagle around that. What the law of war says is it objectively looks at what's happening on the ground. So it doesn't matter if a country declares war, doesn't declare war. Okay, that has changed since the time of World War II. Now, constitutionally, it does matter whether or not Congress has spoken, as Todd has said, and so that's where the AUMF is extraordinarily relevant, and it matters in terms of whether it's going to be revoked, whether it's going to be expanded, extended, etc. On the question of signature strikes, I think the idea of signature strikes, especially the way they've been portrayed, is highly problematic. But it's problematic for a reason other than the one that I think has gotten most people exercised about it. Traditionally, the idea in wartime is that you target the enemy based on your ability to identify them as the enemy. How do you do that? By what they're wearing, right? You don't literally identify the individual as Captain so-and-so or Private so-and-so. You see their uniform, you therefore know they are a member of the enemy forces. So in a traditional construct, signature strikes is simply targeting enemy forces. In today's construct, where we need to have much better information and ability to identify who the enemy is because they're not wearing a uniform, it's highly problematic because I don't know what they're using as the signature. Okay, the signature would be a uniform. It's not now. So what is it? Is it activity? Is it who they're talking to? So it's not the idea of it, it's the operationalization of it that's highly problematic. And that's why they've been extraordinarily criticized, and they also now, I don't believe, are being used. The last point on that is the other 3 Americans who were killed were not killed in signature strikes.
Well, they said they weren't directly targeted, which we can
Exactly.
infer their signature.
No, that's what I want to clarify for you. That doesn't mean that they were killed in signature strikes.
But
What it means is that they were killed as what's called incidental casualties, or a very unpleasant term, collateral damage, which I try not to use because it sounds like the person doesn't matter. And during wartime, let's say you're bombing a building, okay, the command and control headquarters of the enemy forces. That's a pretty important target. You take that out, you deny them the ability to command and control their forces. That's a good one, right? There may well be a civilian in the area who gets harmed as a result of that strike. This is not a person who you could directly target, nor is it a person that you want to die, okay? But we know that innocent people get killed during wartime. That's what makes war such a dangerous enterprise. That's how these 3 Americans were killed. That's what's called collateral damage. It means that they were the incidental harm from a strike. So you're targeting so-and-so, and when you blow him up, somebody next to him also gets harmed. You didn't mean to kill that person. You may have known that they would get harmed, okay? And that's a whole nother discussion in terms of when is that lawful, when is that not lawful. But that's my understanding of why those people died, not the fact that they were sort of just indiscriminately included in.
Well, one of those individuals was Samir Khan, who's an American, I think, obviously he's a U.S. citizen, but English-speaking, who was very active in writing Al-Qaeda's Inspire magazine, whose sole purpose of which...
So we should kill them.
No,
for writing
no.
That's not where I'm headed. But I think it's important to, and this is where this is the next danger zone. But this guy, this is a very challenging issue. If you're the guy in charge of protecting us, it's a very challenging issue, because his goal when he writes this English language magazine is to tell people how to build bombs. The Zarnia brothers relied on Inspire to build the pressure cooker bombs that killed 4 people the week of April 15th in Boston. You know, so if you are the decision maker, and I don't know what the right answer is, I think it's hard. Is Samir Khan a valid target? I don't know the answer to that. Would you have saved lives if Inspire had never been written? Perhaps. And so that's a very tough policy challenge that I think the people in charge have to face at this point. And it gets into just speech and not operational, and that's a very tough area to get to.
I would just like to add, now we're talking about collateral damage. It definitely goes beyond the 3 Americans. Obviously we don't have the numbers, but a senior member of the Senate Armed Services Committee has acknowledged that the program has resulted in the deaths of at least 4,700 people, and independent research groups have verified that at least a quarter of them have been civilians. So obviously the decisions to kill aren't easily made, but it's really much easier for us sitting here in the U.S. Than those people on the ground whose communities are being torn apart because the U.S. government has decided to unlawfully kill people.
Well, I want to thank the panelists for coming and just sort of having this conversation in our community here. One thing that I struggle with, and I say this both as a person with members of the military in my family, also the former, I represent several men in Guantanamo, I think that the juxtaposition of the conversation around drone strikes with what's happening in Guantanamo is one reason why this issue sort of draws on so many passions. I think it's interesting and painful. And I also think, I hear that in the background of all of the legal justification for various actions, there's an element of, well, trust us. This person is an enemy, based on classified information, and there's good reasons many times for information to be classified. But I wonder, that's the struggle that I'm just considering right now. And so, and I think that can breed a lot of distrust, reasonably, And so is there ways that we can kind of push our leaders or get access, better access, to the information that's in the rooms where people are making these decisions? you know, or what can our leaders do better to help communicate that information and earn the trust that they're asking of us, you know, so I don't know if I know the answer to that, I'm just curious.
Well, I mean, they had to, but, I mean, you know, the ACLU obviously had to go to court to try to get access to that information because the government, the whole way this program has been running has been so secret and non-transparent. And, you know, they refused to even acknowledge the existence of the program and the death of, you know, U.S. citizens. And so, as I think I mentioned earlier, a federal appeals court has ordered the government to release some information to the ACLU. And, you know, I mean, the courts have stepped in finally, and so hopefully there will be at least a you know, small measure of transparency.
I think your linkage between ITMO and what we've been discussing is really important in this idea of trust us, because I think that my instinctive reaction to the sort of trust us is really? We know that there are men being held in Guantanamo who have been cleared for release and have not been released because Yemen is determined to be not sufficiently stable. My answer to that is too bad. Send them back, deal with the consequences, be big boys and tell the American people that we are obligated under law to send these people home, and some of them may attack us, but that's the consequence of being a society bound by the rule of law. So that's one issue. Now, naturally, that makes us all a little hesitant to trust the government with regard to things like targeting, which is more invasive towards a person than capturing and detaining them. I want to raise a question regarding transparency. I think it's a very difficult issue, and it's more difficult here than it is perhaps with the detention issue. And it's exacerbated by the fact that the government is keeping more things close to the vest, whether they're classified or whatever, than it needs to. But I want to raise the point, and I think it's very important, that if we are wholly transparent about how we determine who we target, we are giving the enemy a playbook. So if we say we target people who are riding in Jeeps and wearing Casio watches and living in caves, where do you think those who are posing a threat to us are going to go? They're no longer going to drive Jeeps, they're going to drive my Prius, they're not going to wear, I mean, I'm being very glib, but it doesn't matter. If we provide the signature, no, I'm not saying signature strikes, but if we provide the signature that we use to identify who the enemy is, we have given them the playbook to then more. Now, why is that a problem? Well, it's a problem tactically because it's not very smart. It's also a problem because it poses incredible danger for the very civilians in these areas where they are living. The reason, in many cases, not all, in many cases, the reason that civilians are being harmed is because the enemy is intermingled with them. Does that mean we don't have to be careful? Absolutely not. It means we have to be more careful. Okay, but if we give them this playbook, then we are putting more people at risk. And so transparency is important, but it cannot go all the way, because we also have to think strategically, and we have to think operationally, and we have to think about the fact that we are also trying to accomplish a goal in that respect. And so there has to be some middle ground where we don't undo our goal in that regard, but we also preserve the rule of law that we are ideally protecting through this whole process.
We'll take one more question.
Thanks. We talked a lot about the legal framework. I'm just curious as to what your thoughts are on the wisdom of our current drone policy and potential future ramifications, and particularly of interest to me is what does our use of drones in our current policy do in terms of other countries' abilities to use drones down the road?
To use drones there?
Down the road.
Oh, yeah, and then on us.
Mm-hmm.
And then what?
And then on us.
Definitely the wrong policy from a policy standpoint. I mean, just the level of anger that this type of killings has provoked in communities, again, who were not at war in Yemen, Somalia, Pakistan, against the U.S. and against Americans cannot be, put into words. Again, I would encourage everyone here who hasn't listened to the testimony of the man from Yemen, who was here in the U.S. and who had studied an American family and who had all the good things to say about Americans when he went back to Yemen, who, testified before Congress. Just listen to that testimony to try to get a sense of how much damage the drone policy has done to the image of the U.S. In, the Middle Eastern countries. And also, somebody mentioned the reciprocity issue here. I mean, what is to stop China or Russia from deciding that, some U.S. person is an enemy, and they're not at war with us, but, well, that doesn't matter because, war can be,
Exactly.
confused concept these days. So let's just go ahead and drop a drone on that person. I mean, I'm sure everybody here would be very upset about that, and we're going to be up in arms about defending our sovereignty against this invader. So I think, it's really, we are not above the law, we're not above international law, and we're not above the Constitution.
I'm just kind of combine responses to both the last two questions, I'm okay, and sort of give a defensive government response, which may not be too popular. But the fact of the matter is, this is really hard from their perspective. On 9/11 at 10 o'clock in the morning, our government didn't know what happened. I mean, they were caught flat. People were scrambling. We had nobody who understood what was happening in Afghanistan. At the time, you talk about the mission team who landed there, which is a free-for-all in terms of figuring things out. Since 9/11, there's obviously been, dozens of mistakes, that we've all talked about, but I think we should look at our successes. Since 9/11, we have had no attacks launched from abroad hit here in the United States. Okay, that is a testament to the military, the FBI, the CIA, folks who wake up every day and think about this stuff. We've had 65 pops in the United States, and only 3 have been successful. Only Boston was an outlier, and they were on our radar. The JTF in Boston didn't talk. So this has been, I think, a successful sort of defending the homeland. I mean, there's obviously stuff abroad in Iraq and Afghanistan that we could stay here a lot longer talking about. That has been a success. And I think it's been an evolving concept between 8 years of one party rule and now 6, 7 years, and will be 8 years of another party rule. And I think it's the amazing consistency in the policy between the two that I think should tell a company that the people who sit there and look at a threat matrix every day, regardless of what party they're in, are saying, we need these things. And drones are in F-16, and Laurie talked about this. It's not that much of a distinction. It's an unmanned, maybe 150 people working on it, it is manned, but tool that allows us to be more precise. And for an administration that came in saying we want a smaller footprint in the Middle East, it solves that problem. It's also a lot more cost-effective, and we don't have to go rescue anybody. So in terms of an operational thing, it has so many advantages. We didn't use the drone to go after bin Laden for a variety of other reasons, to gather intelligence and verify that we had the right guy and things like that. So just to kind of close up the evening, I think it's important to understand what the people who are out there working for us have done on our behalf. It's also important that it's our responsibility to hold them accountable when they go too far. And that's what I think a lot of the discussion has been here today. And I think we're getting to that point where Americans are like, all right, so who is this endless enemy? Let's define these people instead of seeing them everywhere and under every rock. And let's have a more, and I think the budget more than anything is putting pressure on this to happen, because if we're going to stay safe and be more cost efficient in doing that, we need a better strategy. We can't just invade countries. And we literally can't afford it, and our military can't do it anymore. So I think that's the debate that we're having. I think that's going to be the debate in the next presidential election. I think President Obama intuitively wants to be there. I think that's what his NTU speech was sort of telling us. But I think what he inherited and what he was kind of has to deal with to produce the record he's produced, which is a great record, just like 9/12 on was a great record for the Bush administration in terms of protecting the homeland, everything that he believes.
What about the anthrax attacks after 9/11, 9/12?
In terms of from this enemy, I mean, I don't think those anthrax attacks were attacked at Islamic terrorism. So from this enemy, I think it's been a high success rate. You made a great point that there have been other attacks. When you live in the south side of Chicago, you're not worried about Al-Qaeda, So in that sense, that's not going well. But, we can look at that across the board. But anyway, that's kind of what I want to conclude.
I would throw out to everyone that you think about whether your perception of the targeted strikes, and I'm not calling them drone strikes for a reason, would be different if it was, we had 20 highly trained special forces operatives, each armed with a handgun, bear with me, suspended police, and they were running in and out of Pakistan, Yemen, and Somalia, killing people by shooting them in the head, and they were that good that they could get in and out every time, okay? There are no things called drones. Would this bother you as much as the fact that we have a weapon that right now the other guys don't have?
We've always had weapons. I was in the military myself, and I worked in the Combat Information Center of a ship. I know war. That was my job. And we've always had weapons to be able to do that. You know, we sat outside of Lebanon after the attack on the Marines, and we didn't push a button, for example. And that was a country involved. The problem here is that we're talking about criminals, as you guys have mentioned, not a country. And I believe that, I submit that one of the reasons why this is happening is because there isn't a country involved. So the Gitmo situation that the lady raised, for example, the fact that nobody's complaining internationally about what we're doing is because we're not dealing with a country. And then I also would submit to you that the reason why it is different for us than the Japan explanation, for example, is because we're the only country that has this kind of constitution. And I would submit to you that it never, ever, ever has been superseded, and the Supremacy Clause totally negates any treaty that undermines the language of the Constitution. And it's was it Wright v. Powers or whatever the case is in 1939 that totally lays that out. So to say to us, in my view, that the law of war somehow trumps the Constitution, I don't believe is supported by the history of the Constitution and the interpretations by our Supreme Court. And I believe that these people are criminals. And I do believe that we should have chased them down, even the people from 9/11, as criminals. The fact that we have labeled it an armed conflict, to me, doesn't hold water. We've always dealt with criminals in this country and in the history of the world. We shouldn't classify them any differently. We should track them down. We should arrest them. If they put up a resistance, we should kill them. If we don't catch them, then they're on the most wanted poster like so many other people. You know, this arbitrary system of drones without due process, especially against our system, against our citizens, should not stand, in my view, because it erodes it leads to a Pandora's box in some other area.
One thing is the perception of the military, that the civilian community today really, they don't understand how the military works.
So I think that has to be our last word then. I want to end by thanking our audience for their passion and our panelists for their reason. And I hope we all will, it seems like a lot of people have a lot still to say, and I think there's some wine over there, and maybe...
That'll help us say it.
Thank you all very much.
I'm the co-chair. He's worked for the Laurie chapter of the American Constitution Society. Again, I want to thank our panelists and our moderators for doing a great job tonight. A very fascinating topic, obviously, very strong opinions.
Thank you for your
I'm a veteran too.
You know, and it's frustrating to hear some of these things.
When we tiptoe around our Constitution, we'll become fascist.
All the time. It doesn't matter. We have been doing things.
They redefine words. The Constitution talks about war. War is
I have to tell you, you raised something that somebody told me yesterday, just yesterday, on how
If you're interested in more better organization that we prevent
we twist them and turn them.
or to speak with me or my fellow co-chairs, Sarah Torn, following the conclusion of the program. As Professor Kinkopf mentioned earlier, it's not too late to sign up for our national convention next weekend, June 13th to 15th in Washington, D.C. Notable speakers include Maryland Governor Martin O'Malley, Massachusetts Senator Elizabeth Warren, former Supreme Court Justice John Stevens, and there will also be a Georgia element. We have the 11th Circuit Court of Appeals Judge Beverly Martin is speaking on a panel, Stephen Bright from the Southern Center of Human Rights. We're giving the ACS's Progressive Champion Award to Congressman John Lewis. And also, I'm happy to announce that our chapter will be receiving the ACS Lawyer Chapter of the Year Award.
Nice.
In the event you can't make it up to Washington next week, we'd also like to point out we're going to have a happy hour on Tuesday, July 9th. It's a summer public interest happy hour for public interest law students. We're co-sponsoring that with Arnold Golden Gregory, Sutherland Aswell and Brennan, the Georgia Justice Project, and Georgia Watch, and that'll be at the Lowe's Hotel just up the street. Although we do have some wine available, although we don't have a formal reception, a few of us may be heading over to CAT afterwards to grab a drink, so I wouldn't recommend walking, but if you want to take a car, we'll probably be over there. So thank you very much for coming. Thank you again. Have a good night, everybody.
What's your name?
My name is Bobby Rodrigo, R-O-D-R-I-G-O. I'm with the Legal Research Company. It's a paraprofessional research, and I don't. I actually drove today 5 hours, jumped in the shower. That's why I was late. Jumped in the shower, ran down here, and I nothing. Thank you.
Good point. Thank you for not being rude about it.
I didn't want to be rude, but it was kind of frustrating. Thank you. Well, I think that the civil discourse is important.
It's critical.
It's very critical. My name is Bobby, by the way. Very nice to meet you. We're not going to get anywhere without it.
Well, you know, are you a lawyer?
No, I'm actually a paraprofessional.
A what?
A paraprofessional.
Oh,
Yeah.
okay. I haven't practiced in a long time. One of the things that started to distress me is that when I started practicing, there was a real collegiality.
Yeah, yes.
And I have seen an erosion. And like, I'm this whole thing man, because I think it's really.
You can't do that. You
I
can't
know.
do that.
That's one of the things that. As you say, civil discourse
It is important. I'm involved in a number of national organizations, in the Coffee Party and the Free and Equal, people who put on the third party debates. So I'm an organizer as well in community and stuff like that.
party is so important.
It is, and I'll give you information. I drove today from Middleborough, Kentucky. And I got to my house in Ackworth at 10 to 6, and I got here at 6:50. That wasn't too bad.
No.
That was pretty good.
Did you break any laws?
No, I don't know. They didn't tell me I did.
I'm going to give you my card just so you can send me information.
Yes, I will. Absolutely, I'll make sure and do that.
I'm very distressed about the lack of civil discourse and the gridlock.
Well, I can tell you that we're putting on an event I'll send you everything. Be happy to talk to you about it. We're all over the place. You know, we're concerned about the elections that are going on. The stuff that's going on in North Carolina right now is just crazy. We're putting on a big event in October in Los Angeles. A number of speakers involved. Worth listening to. Third-party speaker Jill Stein, Gary Johnson already confirmed to be there, and a bunch of musicians and stuff. And important stuff. We're trying to make it free to the public. We should have about 40,000 people. That's right. You know it. You know it. I will absolutely send you everything. Okay. Wonderful. A pleasure meeting you.
I love your voice.
Thank you.
Have you ever been in radio?
I have. I do. I was on the radio last night, as a matter of fact.
Okay, there you go.
I try a little. Well done. Thank you so much.
Oh, thank you.
It was wonderful.
Okay,
Thank
good.
you. Thank you so much. Absolutely.
How are you? So you came after I had given my opening remarks, you want, I can email you.
Yes,
Yeah. Thank you so much for
You're
your
very welcome,
comments.
so much,
Yeah.
definitely.
Yeah.
I appreciate your presentation. I support what you were saying, and keep it up. And I'll look into what you're doing. I wasn't aware that I came a little late. I rushed here, but I'll look up the lawsuit as well, and you'll hear from me. So,
Definitely. Thank you so much.
wonderful.
Thank you.
Take care. Good night. Yes, certainly.
That was great.
Thank you. You're welcome. Bobby Rodriguez. Thank you.
Oh, yeah.
Oh, wonderful.
Yeah.
Wonderful. Hi. That's sweet. I like it. Hello. Very, very nice to meet you.
Talking about Karen Hughes, talking about.
Yes, no, I remember.
Yeah,
I was there.
talking about Paul Brown and
I was
how,
there.
we got supporting Paul Brown.
Marvelous. I'm gonna